Hello and welcome to interest.co.nz. I'm Gareth Vaughan with another of our Doubleshot interviews, and I'm here at Minter Ellison Rudd Watts with Stacey Shortall, who's a partner at the firm. Now we're going to be talking about the bank fees class action or representative action. Minter Ellison Rudd Watts and Stacey Shortall, neither of them are representing anyone in this case, but Stacey has a decade or so's experience working in class action suits in the US. Thanks a lot for your time, Stacey.
No problem.
I thought we could kick off by just talking about maybe what bank customers who are considering signing up for this case should think about before they commit or not to doing so.
Well, I understand there's a website that has been put out, Fair Play on Fees, and I'm sure that contains some quite detailed information around the pathway to the litigation in terms of the funding agreement, in terms of the arrangement with the lawyers, what the background is, the expectations, at least on the plaintiff side, are. So that should be read closely, and I would in particular focus on the extent to which the litigation funder is going to take a proportionate share of any damages, if any ever get awarded here, how the lawyers are going to be compensated. In my experience in the US dealing with litigation funded cases, there were occasions where the funder was also getting recompensated in whole for any out-of-pocket expenses, photocopying, other sorts of disbursement charges. I would look at are those going to get reimbursed in full, who's providing those services, ensure that there's fairness to all of that. So understand what the commitment is, whether, if damages are awarded, who's going to get a piece of that, how it's going to be divided, and of course the starting point in any of this should be to think hard about whether or not you as a customer belong in this action. So, will you charge fees? What were the circumstances in which that occurred? Have you spoken to your bank around this? I mean, the starting point for all of this, I'm a lawyer, but I believe that as few things as possible should find their way into a courtroom. There are a lot of other ways that things can get dealt with, and speaking to your bank would be a starting point. So, two pieces. Make sure you understand what it is that's been offered here, and make sure you believe you belong in the lawsuit, and talk to your bank. Talk to your bank.
Now, this has been running already for, I think, almost a year, off the top of my head.
Right.
The cases have been taken against ANZ and Kiwibank by Fair Play on Fees. They've also pledged cases against ASB, BNZ and Westpac. Obviously, these things take a long time. Just wondering, firstly, up to this point, whether things have sort of played out the way you might have thought they would.
As far as I understand it, yes, I believe statements of claim are on file, statement of defence where they've been due have been filed by the defendants in those cases. The US model around class actions, which is different to representative actions here, has an upfront feature around certifying the class, the court determining whether the litigation should actually proceed on a group basis up front. So there would be procedural work that would happen there. Doesn't belong as readily in the New Zealand procedural setting, although there are ways to challenge a representative action being brought in the first instance. I don't know whether the defendant banks are looking at that here. I would expect that they would pay some attention to whether this properly belongs as a group litigation. But otherwise, the sequence is right. Your point is a very good one, that this does take time to move forward, and I would expect that it will continue to take quite some time.
And, I mean, how do you think it could play out from here? I mean, obviously, we've talked about this case previously, and you said that a lot of the cases that you were involved in and followed in the States, for example, never actually made it to court. They settled, or something happened before they got to court.
Yes.
I mean, that's surely on the table here, that there could be a settlement in this case at some point.
Well, as far as I understand it, the banks have said that they intend to vigorously defend the litigation, and based on what I understand the facts to be, that makes absolute sense to me, that would be the defence strategy. Whether or not that ultimately results in some discussion at some point in the future that leads to a resolution short of trial, it's always possible. The US experience is certainly that cases do tend to settle, class actions in particular, not because of the merits always of the claim, but for very logistical, practical, commercial reasons around the expense of defending a claim, the distraction of management time and personnel time dealing with it, the reputational consequences, commercial consequences. Insurers sometimes have a view on whether, if they are involved in paying for defence costs, whether cases should continue or not. So, look, whether any of those factors ultimately become part of a strategic decision that's made by the defendants here, only time will tell. But in all of those settings where I was involved as defence counsel, then those discussions were some way out into the case. You know, you put the plaintiff to significant burden up front to establish that there was some claim there. And if there was, then you might entertain some type of discussion for purposes often of avoiding unnecessary cost and instead using that money to provide some degree of compensation. But I think it would be too early to tell here. There's been no discovery phase from what I understand at this point, so documents being exchanged to the point that they could be assessed, witnesses being spoken to and briefed. You need a lot of that work done before you can form a view around that.
A lot of water to flow under the bridge.
A lot, yes.
In terms of the merits or not of the case, what do you make of them at this point?
I'm not in a position really to comment on that because I don't know what the underlying facts are. And I think that's important for customers to keep in mind too. At the moment, we are hearing, by virtue of what the plaintiff's lawyers and funder announced at a press conference, which is an interesting strategy in and of itself, and then what they have released into the public arena, we're hearing one side of a story. Now, I understand that there have been some statements of defence filed, but they'll be fairly bare bones at this point. The obligation is not on the defendant to come forward and tell all of its story at this part of the case. So, look, I don't know what the merits of the case ultimately will be, and no one does. I think that's important to keep in mind. The system, the judicial system around this and the process that is followed will enable that to be determined. But at the point we're in now, we really have one side of a story.
And I mean, the case really boils down, in my understanding, to obviously it's about exception fees, what we call exception fees. Fair Play on fees is arguing that the banks, charged way more than they should have for these fees. The banks are obviously saying, no, we didn't. Now, really, in terms of that, I mean, if that's the real guts of the argument, I mean, who are we going to believe here?
Well, there'll be, I'm sure, a lot of factual questions around the different circumstances in which those fees were charged, what, if any, notification in advance customers have, what, if any, discussions they had with the bank in advance of behaving in a way that caused the fees to be charged. There will be, I anticipate, considerable expert evidence around what was or was not a reasonable fee to have charged in those circumstances, what, if any, costs the bank bore in connection with dealing with customers who put themselves in situations where fees were charged. So there's a lot of factual information in there to be bottomed out. So at this point, I would, if I was looking at this litigation from the perspective of a bank customer, then I would take both those views into consideration and I would think about how I had interacted with my bank, what discussions I had had before I get involved in the litigation.
Now, will the onus really be on Fair Play on fees to prove that these fees that the banks charged too much for these fees?
Well, they're the ones bringing the case, right? So they're the ones that have made the allegations and the burden sits with them to establish that this case does in fact hold water. So they've alleged claims and they will need to put on evidence to establish those.
Now, we've obviously had a similar case in Australia, brought, I must say, by a different group against the banks over there, but over the same issue, exception fees. One case there involving ANZ has been to court. Now, there were 5 fees in dispute. 4 actually the bank won on. The one they didn't was credit card late payment fees.
Yes.
We had a Commerce Commission Commerce Commission guidance given on this in New Zealand back in 2010. To what extent do you think that the Australian case is a factor in what's going to happen in New Zealand, and is this good or bad news for the banks or fair play on fees?
Well, I think the New Zealand litigation will have to stand and fall on its own legs. So any decision as in Australia has no precedent effect legally in a courtroom here in New Zealand. It may have some influence perception-wise as to whether people want to join the litigation or not join it. I've certainly seen that there has been some reference made by the plaintiffs' lawyers here in New Zealand to success as they've deemed it in Australia. But as you note, I think it is material that there were 5 categories of fees pursued there. Only 1 is left standing, although the case is that decision is on appeal. Yeah. But the extent to which that's relevant here in New Zealand, I would say is marginal, because there are going to be, the law's different, the facts will be different, and the case will need to be established in this setting there's no ability to transport what an Australian court heard or found over here for a New Zealand judge to look at.
Now, when Fair Play on Fees and Andrew Hooker, the lawyer who's representing them, announced this action last year, they talked about going back 6 years, which is under the statute of limitations. And that their very rough estimate was there could be $1 billion worth of exception fees from the big banks through that period. In terms of that statute of limitations, he's looked at this Aussie judgment and seems to think now that they might be to go back decades, as he's put it, or at least double the time of the 6-year limitation. What do you make of that?
I don't know where he's getting that calculation from or what the basis is for that statement. The statute of limitations here in New Zealand provides for 6 years from the point that a plaintiff either knew or should have known about an issue. So it may be that part of his theory is that customers weren't in a position to know that there was an issue with these fees until much more recently. But I'm not sure what the basis is there, but the material point is that question as to when people either knew or should have known will be a hotly contested topic, I would think, because it will be material in the event that the claim does in fact have merit, very material to any damages award, the period of time for which those damages can be sought. So I think that will be a question that will feature early in the litigation, but I don't know what he would be using as his basis for claiming that it could go back decades.
A couple more questions just to finish off with. I'd be really interested if you have any views, as we sit here today with what we know today, what you think the ultimate outcome of this might be, and also whether you think there are ramifications for other industries other than banking out of this.
Well, I think that it's an opportunity for a very public lawsuit to be litigated as a group litigation. And there haven't been a lot of group litigations brought in New Zealand that have garnered the same level of public interest. And that has caused people perhaps mistakenly to refer to class actions here in New Zealand, the bank class action. It isn't. It's a representative action, no class action regime in New Zealand. There have been those who have said we need a class action regime in New Zealand. The fact that this has been brought as a representative action successfully, at least at this point, would indicate, well, there is an avenue already existing for group litigation to be pursued. So that it could be an example as to why, if others are calling for a class action regime, it's actually unnecessary. That could be a ramification. Look, I am actually an advocate for group litigation. I spent 11 years plus in New York defending class action lawsuits, but also observing the way in which group litigation there had been a real avenue of social change. Much of American history around African American rights, gender rights, gay rights, discrimination issues were driven out of class action litigation. So much social reform in that country was a result of a class action regime. So there's a lot of good that comes with group litigation. I wouldn't want there to be any suggestion that I don't support it used properly. But I think where there is some measure of danger or things to be wary around involve litigation funders. People need to fully understand what they're signing up to when funders are involved. And again, they have their place. I'm not saying that they should not be part of the system. They have their place, but people need to understand what the terms of that arrangement is, what they themselves are going to potentially receive versus what the funder and the lawyers may receive, so everyone goes into this knowledgeably. If this action is successful, if there are large damages awarded, then the American experience would indicate that once people see some success in one area with group litigation, more follows. Once one litigation funder sees success, more get involved. So it can be a trigger point, a flash point for more litigation. So I would certainly say to entities, financial institutions, corporate entities that are involved in service delivery industries where they deal with a lot of customers, that this is something to watch and watch closely. And if as a result of this experience, however it goes, it means that people engage differently, potentially better with their customers, then there is an upside for everyone.
Absolutely. Thanks a lot for that, Stacey. That's Stacey Shortall, who's a partner at Ellison Rudd Watts, and I'm Gareth Vaughan at interest.co.nz.